My name is Carolina Rengifo, and I will be speaking as an expert in international humanitarian law. Today, I will be looking at the intertwined relationship of the framework of the Global Ammunition Management Framework and international humanitarian law. I did not bring a presentation, so it'll just be me. I'll try to guide you through my words and intervention. As I was saying, this relationship is very strong, and from now on I will be mentioning international humanitarian law as IHL and referring to the framework as GFA, just to make it shorter. Our hope here today is that our path towards the 2027 meeting of states will translate in that in both international binding and non-binding agreements translating to actions, right? So we have the IHL, which is a binding piece of law, and the global framework, which is a non-binding one. The GFA's principles and practices directly and indirectly contribute to the respective IHL. This is especially important as our case studies in Syria, Libya, and Iraq, and all of the Middle East and Northern Africa. Even though Iraq is not a signatory of the protocols, Libya and my apologies, Libya and Syria are, and the three of them are signatories of the Geneva Conventions. To give the audience a bit of guidance throughout my presentation, I will be structuring as it follows. First, I will be reviewing the shared fundamental principles between the GFA and IHL. Then I will mention a couple case studies and conclude with a small and brief takeaway. So the objectives of both GFA and IHL converge on a single imperative, which is minimizing human suffering during and after an armed conflict. This shared goal is implied in the control and accountability of ammunition throughout its life cycle. So beginning with a key core and shared principle, which is the protection of civilians, in international humanitarian law, the protections who are either not participating or not longer participating in hostilities is key. This includes civilians, the wounded, the sick, detainees, etc. It mandates that all participants to a conflict adhere to the principles of distinction, proportionality, and precaution, ensuring military operations do not disproportionately harm civilians or civilian objects. Here's where GFA comes through to provide practical measures to ensure that countries that have signed the Geneva Conventions comply with these legal framework. So while GFA is not a legal treaty, it provides the practical tools to help states fulfill these obligations. It offers technical and operational guidelines that minimizes risks associated with ammunition, such as accidental explosions, diversions, and illicit proliferation, as we have been seeing with our previous panelists. These risks, if left unmanaged, lead directly to civilian casualties, displacement, and the breakdown of humanitarian protections envisioned by IHL. So let's now walk through a few connections between GFA and IHL. So the first of them is preventing diversion and illicit trafficking. One of the most critical challenges facing ammunition management, particularly in conflict-affected regions like the Middle East and North Africa, is diversion. When ammunition falls into the hands of non-state armed groups, it often fuels indiscriminate violence, extends the duration of hostilities, and results in IHL violations. The GFA addresses these challenges through lot marking and traceability measures, inventory reconciliation, and securing storage and transportation systems. These measures are not merely technical, they are foundational to safeguarding humanitarian law. When states prevent diversion, they cut off the supply chain for IHL violations, such as the targeting of civilians, torture, or the use of explosive weapons in populated areas. Second is the reduction of unplanned explosions at munition sites. We have seen this in the past in the region. The second connection relates to a silent but deadly threat. These events caused by poor storage, lack of surveillance, environmental degradation have had catastrophic effects on both civilian communities, especially in Libya and Iraq. The GFA's objectives is to mitigate and prevent unplanned explosions, and it's aligned with the IHL's requirement to take feasible precautions to protect civilians' lives and infrastructure. These explosions are not random accidents. They are often a result of neglect, poor planning, or limited capacity. By implementing these GFA protocols in the region, states demonstrate compliance with IHL by practically addressing threats before it results in humanitarian disasters. Third, we can look at transparency, traceability, and accountability. This third overlap lies in promoting transparency and accountability mechanisms, which are vital for both operational effectiveness and legal compliance. The GFA advocates for ammunition marking and record keeping, enable munitions tracing from manufacture to disposal, and facilitates forensic investigations into the misuse of ammunition. This helps states meet their IHL obligations to ensure that weapons and ammunition are not transferred to parties likely to use them in the violation of international law. In practice, this supports efforts to document potential war crimes, prosecute alleged violators, and strengthen international cooperation on arms control. These measures can also help prevent arms transfers that may enable or facilitate atrocities, including through regional and monitoring frameworks. In summary, while IHL defines the legal norms of conduct of war and GFA provides technical means, they're fundamentally intertwined as it's a partnership between the law and the life-saving action that GFA can provide for IHL compliance. So we encourage the GFA application in the region. To go into the second part of my presentation, which will be brief, I will be mentioning a couple case studies. As my first colleague panelist mentioned in the first presentation, since 2011 in Libya, there's been more than 12 ammunition explosions. To give an example, in 2021 in Garian and in 2020 in Misrata, resulting in civilian deaths and displacements. On the one hand, IHL sees this as a breach of the additional Protocol 1, which states the principle of distinction and precaution, things that could have been prevented or mitigated with the application of our framework, the GFA, which proposes a risk-based assessment, stockpile relocation, and demilitarization of the region. On the other hand, to give you a second example or case study, in Syria and Iraq, the diversion of ammunition to non-state armed groups has been quite frequent in the past. Between 2012 and 2019, tons of ammunition under the state and foreign military control diverted to the hands of a non-state group like ISIS and other, which prolonged conflict and therefore civilian suffering. Once again, IHL revises these actions and in its Geneva Convention, Common Article 3, states the prohibition of indiscriminate attacks and obligation to protect civilians. And GFA could have helped preventing this with the traceability, verification procedures, securing storage, and lot marking of the munition. So we could cite many more examples, like the diversion of munition during military training in the region, or regional trafficking, illegal regional trafficking. However, I would like to just summarize it all with a bit of a takeaway of my presentation, to say that when states apply GFA's practical measures through stockpile management, risk assessment, diversion prevention, they meet both technical benchmarks and also they fulfill IHL obligation to protect civilians and reduce humanitarian cost of armed conflict. That said, thank you very much, and I give the floor to my colleague.